The new business rule bars fledgling businesses from recovering anticipated lost profits in contract breach claims. Some courts reject this rule because it creates an unfair catch-22. Such was the case in Chung versus Kaonohi Center Company. Ferent Chung and Jordan Lum signed a 10-year lease to operate a Chinese restaurant in a mall owned by Kaonohi Center Company. Kaonohi didn't inform Chung and Lum that it was negotiating with others and had already given a right of first refusal to someone else. Over the next 18 months, while Kaonohi constructed the space for the restaurant, Chung and Lum secured financing, bought equipment, and hired staff. Kaonohi knew about those preparations and repeatedly assured Chung and Lum that the space would be ready for them. Chung and Lum confronted Kaonohi when a newspaper reported that Sergio Battistetti had secured a lease to open a Chinese restaurant in the mall, and Kaonohi denied it. Kaonohi then backed out of the lease with Chung and Lum and leased the space to Battistetti. Chung and Lum sued Kaonohi for contract breach, seeking damages for lost anticipated profits and emotional distress. Their expert witness used an income stream analysis to estimate that the restaurant would have made a net profit of about $225,000 over the 10-year lease. The expert testified that he started with the actual gross profit of Battistetti's Chinese restaurant and subtracted estimated expenses based on industry standards, explaining each line item in detail. Kaonohi challenged the expert on cross-examination and presented an opposing expert who provided a much lower profit estimate. The jury awarded Chung and Lum $175,000 for lost profits and $50,000 for emotional distress. Kaonohi moved for a mistrial, arguing that an unestablished business couldn't recover lost profit damages, and that emotional distress damages weren't available for commercial contract breach. The trial court denied Kaonohi's motion. Kaonohi appealed to the Hawaii Supreme Court.